The difference between a warrant complaint and a summons complaint in the state of New Jersey. At the Bianchi Law Group, located in Parsippany, New Jersey, we often are asked questions by people as legal TV analysts and or in our law practice, questions that keep coming up over and over again that people don't quite get satisfactory answers when they're going on Google. So hopefully these videos will be helpful to you. And one of the main questions we get either before a person is arrested or during the process of the arrest is, what is the difference between these terms, a warrant and a summons arrest? They have critical differences in the state of New Jersey, them being as follows. A summons complaint will start with an S number on your complaint and it'll have a number afterwards. That's the lesser significant one. A summons complaint means that you come into court, you receive your complaint, or you go to a police department, you receive your complaint, but you're free to leave. And obviously, that's a biggie because you're free to leave. The warrant complaint, however, is different. That'll start with a W and then a number afterwards, W for warrant. And a warrant complaint means that probable cause has been established by law enforcement before a judge to actually arrest you and to begin the detention process. So a warrant complaint is more serious because you will be fingerprinted, photographed, mugshots, the whole thing. And there will then go into the detention process. Now, the detention process is complex, and you need to know that because it's really, really important in the initial stages as to whether you're going to continue to be detained or whether you'll be released. That will be in a different video that you certainly can check out at the Bianchi Law Group. But let's stick now with the summons complaint first, the warrant complaint. One of the things that we try to do if we know in advance that law enforcement may be investigating or looking to charge our client is to try to convince them to put it on a summons complaint rather than the warrant complaint. And again, it's for the very practical reason that on the warrant complaint, we don't have to then go through the detention process, which clearly our clients don't want to be in jail waiting for that to happen. And of course, we don't want them in jail as well. Now, what would be the reasoning as to whether or not something is going to go on a summons complaint or a warrant complaint? Well, typically speaking, and I'm going to break it down as simply as I can, there are degrees of crimes in the state of New Jersey. First, second, third, and fourth degree crimes. First being the most serious, fourth being the least serious. Some carry mandatory jail time. Some crimes have periods of parole ineligibility. So when things go on a warrant complaint, typically speaking, you can be assured that law enforcement is generally seeing this as a more significant offense. It's a more formalized process, and it's a process at beginning. The detention hearing will ultimately, prosecutors, the judge, with the participation of defense, there's going to be determination as to whether or not you will continue to be incarcerated or held over, waiting for your case to be disposed of, or of course, like we have in the summons complaint, whether you can just be given the piece of paper and then you can go on your way. In either event, I cannot underscore enough that this is a frightening process and you're disoriented and you're scared. And the bottom line to anything, and this applies to the innocent as well as the guilty, is always to remain silent. It's golden rule number one. Remain silent throughout the process. Anything you say can and will be used against you in a court. Well, you hear that on TV, but you know, it's one of the few things on TV that's true. And we've seen it time and time again. Also, keep in mind that if you're in a situation in which you're incarcerated, again, you're keeping silent, you're asking for your attorney. This does not mean that you've done anything wrong. They should honor that request for an attorney to remain silent scrupulously under the law. That's the word they use, scrupulously. So don't be dissuaded by unscrupulous tactics that try to get you to talk like, you know, well, if you didn't do it, why wouldn't you talk to us? And hey, I wasn't going to charge you. It wasn't going to be a big deal. But now that you invoked your right to remain silent, you must be guilty. Don't fall for it. If there's something that you need to speak to law enforcement or prosecutors about down the road, do it with the advice of competent counsel. So the two golden rules: remain silent and hire the best lawyer you can afford. Lawyering makes a difference. So again, a summons and a warrant, they're just words that we use. The charges are the same. It depends on whether or not the process afterwards, how the process afterwards is affected by whether it's a summons or warrant complaint. If you should have any questions, of course, you can always call a competent defense lawyer. Most important thing you can do. And of course, we're always available here at the Bianchi Law Group to help you. We're a team of former prosecutors, and we're very proud of what we do. And we're really happy to be able to give these instructional videos. I hope this was of help to you.